Bonnie, how are you guys tonight? So as I was saying, if you guys have any questions, please type your questions in and they will be read to me and we'll answer those accordingly. We are recording this on Zoom separately so that I can put it on my website for future viewing, so that if you ever want to go back to it, you can see it. I don't know, does this record on Facebook, or is that it's just a live stream?
I believe it will save as a recording.
Okay.
We can choose whether or not to share it on Facebook.
Okay, so what we'll do is we'll get started. Today, my conversation is going to be about some of the basics with estate planning, different important things to look at, different aspects of estate planning. I haven't done one of these in about 4 months, so I'm probably a little rusty. So bear with me a little bit. Most of this stuff comes off the top of my head. I do not have a really specific outline, but I've done so many of these that I kind of fly by the seat of my pants. So as I said, don't hesitate to ask questions, because I think it's really important that I get information to you guys that you want to know. Okay, so I'm going to start with taking the sign down, and we're going to talk about the important basics today. The important, very basic elements of an estate plan are 3 pieces. I'm going to start with the one that probably you know of, and that's the will. Now, I assume you know what a will is, but the will is a document you create to distribute your assets at the time of your death. Now, why is this important? I think a lot of people believe that they don't need a will because they're married and everything's going to go to their spouse and there's nothing to worry about, or they've got kids and it's just going to pass to their kids. Some of that's true, some of it's not. But I will tell you, if you have a spouse and children and you don't have a will, it doesn't all go to your spouse. And it's very important to understand that. And it's also important to understand that creating a will, particularly if you have young children, is important, because you need to protect those young children from the law. The law says that they will inherit at age 18. Now, I don't know if you know any 18-year-olds, but I know a couple and I've had 5 children. So I have yet to see or meet an 18-year-old, at least in my lifetime, that could really handle any kind of reasonable inheritance. So what we do is we create a will that puts it in trust for them until they are usually 25, sometimes 30. So it's really important that you have the will created that has the rules in it. The will's got to have rules. Okay. Now, not only does it distribute, but it creates the trust for the children. In addition, something you need to understand is whenever you have a will and assets will pass through it, there's a process called probate. You may have heard of that process. You may have heard that that's a scary, terrible process. It's not true. It is a process that works. It means that it is a process where we file the will with the court. We file a death certificate, a petition, and waivers from all the distributees. Distributees are those people that need to be put on notice when someone dies. You might be surprised to find out who those are. For instance, if you die and you are married and you have children, your children are distributees. They have to be put on notice and they have to sign off on your will, even if you leave everything to your spouse. These are important things to understand because the process can take time, but it still works and it's a very effective process. Okay. So the will distributes to loved ones. And the will overcomes the state's plan. If you die without a will, the state has a plan for how your assets will be distributed. The will, by you creating it, overcomes the state's plan and allows you to create your own plan. If you are married, if you have children, if you are living a normal life, you should consider having a will in place. It's really, really important because creating your own rules and your own plan is important. Okay? All right. So the first step is will. Easy. I think we understand what that is. I hope we do. Let's get to part number 2. And that is the healthcare proxy. probably the easiest, simplest, most straightforward document that we have in our basic estate planning arsenal, and that is appointing someone to make healthcare decisions for you. Now, I will remind you, or at least tell you, that New York State provides statutorily, so written in the law, that you have people that will make legal decisions, or I'm sorry, healthcare decisions for you if you don't appoint someone. You must understand, though, that those people may not be the people you want to choose. So there's a hierarchy that starts with a spouse, a live-in partner, children, oldest to youngest, etc. But if you have someone that in that hierarchy that you want to choose out of order, you need to do a healthcare proxy to pick that person. In addition, you may want to insert some rules in that healthcare proxy. For instance, you may want to tell the healthcare agent how you wish to be treated at end of life. What happens if you are brain dead? What happens if you're in a persistent vegetative state? How do you wish to be treated? Do you want artificial nutrition, hydration, and ventilation? If you don't, you really need to put it down so they can understand your wishes and your rules. Do you want organ donation? Some people have it on their licenses, some people don't. But this is a good place to put it so that we understand what your wishes are. How about disposition of your remains? What we don't ever want is for there to be a fight about what to do with you at your death, your body, your remains. Who's going to be in charge of that? Do you want to be cremated? Do you want to be buried? Where, when, how, all that stuff. Okay. So this is a good place to put some of those things down so that the family is very aware of your wishes, even if you become incapacitated and can't relay those wishes. And now they know what you want and what to do with you and with. Okay. So the healthcare proxy is more than just simply appointing, your husband or your wife to make healthcare decisions. It's about putting some of those wishes down on there so that we know what to do. All right. Very important that you make those decisions and not somebody else. Doing a good estate plan, whether it be a basic estate plan or more advanced, is always about you making the decisions and not somebody else. It becomes more and more important as you accumulate wealth, as you have more children, as your life becomes complicated. Blended families, same-sex families, very different legal issues with those families, very different practical issues. So having a good estate plan becomes vital when you're trying to establish who gets what when you die. And I'm probably going to touch on some of those issues in a minute. Part 3 is the power of attorney. So the 3 main components of an estate plan: will, healthcare proxy, power of attorney. I think most people don't understand how important the power of attorney is. Of the 3, this is probably the most critical, because as I said before, New York State has a plan for your assets if you die without a will. New York State has a hierarchy for your healthcare proxy if you haven't appointed someone. However, New York State does not have a plan in any form if you do not have a power of attorney. Because if you haven't appointed someone to make legal and financial decisions for you, if you become incapacitated, then your family, your stuff is stuck. Nothing can be done. And I can't tell you how important this is. Paying bills, selling assets, transferring assets, planning for nursing home costs, protecting assets, any number of things that just simply paying your bills is critically important. Got to have a power of attorney. Now, not all powers of attorney are created equal anymore. We now have the ability to add gifting onto these powers of attorney. Now, why would anyone want your agent to be able to gift your assets? Well, in my world, it's not really about gifting. I really call it transferring. Okay? What that means is the power of attorney, the person you appoint that you trust to make decisions for you, has the ability to transfer assets out of your name. Now, why would that be important? Well, if you go into a nursing home and you have all your assets in your name, then the nursing home can take those assets. If, however, you go into a nursing home and you can transfer those to a spouse, a disabled child, a child caregiver, or you can do a Medicaid plan that protects those assets, then you have the ability to provide and leave some of those assets to your family. A good power of attorney will allow you to do that. Without one, you are stuck. And the only other option is what's known as a guardianship. And that is a whole legal process that requires you to hire lawyers, go to court, file petitions, spend money, spend money, spend money. Because it takes at least 2 to 3 lawyers to have that process effectuated. It takes at least 60 to 90 days to make it happen. And it probably costs a minimum of about $5,000 just to do a guardianship proceeding, to get one person appointed to provide guardianship over another person. It also means that the court has to approve anything you do to protect assets. With a power of attorney, which costs maybe $300 to $400, no court oversight, no court approval. You don't have to ask the judge for a court order to do anything. It's expeditious, it's effective, and it's much more, cost savings is obvious. So you create, and I should not forget to point out that the guardianship usually leads to someone being appointed guardian, but that person may not be the person you want appointed guardian. With a power of attorney, you get to choose the person that you trust to make the decisions for you. You don't get that luxury with a guardianship. Really, really important that a power of attorney is done. If you take nothing from this webinar today, please take with you the importance of having a power of attorney drafted. Okay? All right. So those are 3 basic elements. We call them the great triumvirate, right? Will, healthcare proxy, power of attorney. Those are must-haves for anyone trying to create a basic plan. Now, a couple of things I want to talk about because they are important, just with respect to the will for a second. So if this is your will, and let's say this is a married person with children, and we want to make sure that the children, and these children are, say, under 10 years old. What we have is usually we have a house, some joint assets, and maybe some IRAs now, because a lot of people are getting IRAs. And hopefully we have some life insurance, because life insurance is a really, really important component for my young clients with young children to make sure that they've put money aside to replace their income and to help pay for debts as well as college. You may know that right now private college is somewhere around $300,000 per child. It's staggeringly expensive, and that makes life insurance incredibly important. I can't stress that enough. Here's one of the biggest problems with life insurance, though. Generally speaking, someone will leave life insurance to their spouse. That's great. That works fine. But who's the contingent beneficiary? Who do they leave it to? Boy, I can't spell today. Contingent benefit. Who do they leave it to if they and their spouse die together at the same time? A lot of times, I find that my clients have the wrong contingent beneficiary. So who are the wrong contingents? Well, how about the kids themselves? They're the wrong beneficiaries because they're minors. You can't leave it to minors. How about your parents? That's great. They're older than you. You want to leave them lots of life insurance. What if they're in a nursing home? What if they're sick? Not a good idea. How about your siblings? We love your brother Steve, but we don't want to leave him $500,000 in life insurance because even though we trust him, he could die. He could get sick. He could take the money and gamble it away. He could run away with it. Now, I know it's probably not going to do that. However, we want to ensure that the kids get the money and not Steve, his ex-wife, his new wife, his kids, whatever. Okay. The mailman. I was joking with my clients when they come in. We don't leave life insurance to the mailman. I hope you know that. The next door neighbor. Kids, parents, siblings. These are the 3 most common contingent beneficiaries I see. These are all wrong. What we should be doing in a perfect world is we create trusts for the children in the will. The beneficiary should be these trusts. Worst case scenario, we leave it to the estate and it still gets to the trust. But we need it to end up here because this trust puts a trustee of your choosing in charge of the minor children. And that trustee has rules inside the will as to how to use this money for them. And it also allows us to change the age from 18 to 25 or 30 or 35 or something like that. Once again, 18-year-olds, I feel, generally speaking, are ill-equipped to inherit money, particularly if we have two parents with sizable life insurances and retirement accounts and houses and things. We don't want kids getting, $1 million, $500,000 at 18. That's a recipe for disaster. So really, really important that the will is set up with the right trusts and that the life insurance and the assets are set up. And not only life insurance, but IRAs too. IRAs need to be set up properly. IRAs, 401ks, 403bs, TSPs, those kinds of retirement accounts need to be set up properly, okay? So this is a, generally speaking, this is a plan that we would do probably for 55 and under, most of the time with children under 25. And it's a basic plan, not overly expensive, but really, really important to have the rules in place just in case something happens. I call this, our what if something happened suddenly plan. This is a plan for someone who dies accidentally, who dies from a heart attack or stroke very quickly or aneurysm. This is not necessarily a plan that we might use if you got sick with cancer and we had time to plan knowing that you might pass. This is a plan that says, husband and wife, we don't know who's going to die first. We're going to create a protection for your children. So very important that we have these pieces in place, but do not forget, this is the most overlooked piece. I have a lot of people that come in and have gone and have done a will somewhere. I said, will's great. What about this? And they look at me like I got three heads. No, I left it to my parents or my kids or whatever. This piece is incredibly important. Okay. All right. So that is the will and kind of how the will works. Obviously, with each family, it's a little bit different. One of the things I should touch on just for a minute is blended family issues. Blended families, which are becoming increasing in number. I'm seeing people come in every day, not every day, but frequently with his, hers, ours children. And when you have families with husbands and wives with different children, we have different goals. We have a different hierarchy of importance with respect to the children. You may not feel the same way about your stepchildren as you do your real children, your biological children, sorry. And of course, that means that your goals are different. If you use a traditional estate plan where we have two wills and you leave everything to your spouse at your death, and the spouse has all the money here, okay? And then the spouse dies, the spouse, and if you have children here and children here, the spouse can leave everything to his or her children and none to the children of this spouse. Okay, this is a bad plan. It is very, very difficult to use what we call a sweetheart will with a blended family. It's really important that you create a plan that accommodates your goals to make sure that both of the sets of children receive some kind of inheritance if that's your goal. It takes a little bit of thought. It takes a little bit more planning. It takes a lot of understanding between the two people. And frankly, we have some difficult conversations in this room at those times. We have to be honest with each other about what our ultimate goals are. As I said to someone yesterday, we start with a series of facts and we get to a series of goals. And in between, we have a lot of conversations and sometimes arguments about how we get here. But we always get here one way or another. It's not always perfect because it's a difficult situation. Once again, life insurance becomes an important factor in a case like this because the first to die can leave life insurance in trust for their own children while passing the rest of the assets on to their surviving spouse. That works as a relatively easy way to do it, but it's important. Is that a question?
We do have a question. The question comes from Bonnie. I'm nearly 60, single with 5 children from 31 to 40 years old. What should she look for? What do I need to look into?
Aha. Okay. So there's a couple things. I'm going to talk about this because my next move is going to adjust as I start moving towards your age group, which is still young, by the way. Okay, you're not officially old in here until you're over 85. So I hope that's good news. So to answer that question it's important to understand your goals. So I'm not going to ask you what your goals are in this forum, but I want you to think about what your goals are and what you try to achieve. And I know sometimes I have people come in here and they say to me, I'm not sure what my goals are. You need to help me. What could my goals be? Well, your goals could be, we want to protect assets from nursing home. That's often, probably most often what I hear. I want to be sure that my kids get my stuff easily without a hassle. I want to be sure my kids don't fight. Sometimes it's one of my kids deserves more than the others, or one of them deserves less than the others. How do I do that without creating a problem? So it depends on your personal goals. What you should be looking for in particular is identifying your assets and making sure you know what you have and where they are. Being very clear about that with the attorney, and being able to elucidate upon what your goals are. What is it you're trying to accomplish? What's most important to you? I'm going to give you some ideas today, things to think about, because that may create a situation where you say, oh, I like that. That's important to me. So that leads me into my next section, which is really talking a little bit about trusts. So first we started with the basics. Now I'm going to talk about the basics with respect to trusts. And then hopefully this will wrap around some of the things you might be concerned about. So there's two main types of trust. There's 25 different kinds of trusts, but there are two main types. One is a revocable trust. And I'll start with this. This trust, we treat this as an open box. And this box allows you to put assets in it and take assets out. The difference between a trust and a will is that your trust actually will own assets. So it owns stuff while you're alive. So we would have your house go into your trust, and your money and your investments and your life insurance go into the trust. Why is that important? Well, it depends on, part of it depends on the nature of your assets and the amount of assets. The wealthier you get, the more inclined you are to use a trust, because this means that we will not have to use the probate process when you die, which means also that your assets will be private from public viewing. The probate process is a public process. So if you die with a will and someone wants to go down to the courthouse and see how much money you had and who you left it to, that's open. Anybody can walk down and see it. I can go down and see Jacqueline Onassis, just by way of example, her will is, you can find it on the internet. It doesn't tell how much money she has per se, but you can find out because it's all public record. So this privatizes it. This keeps out of probate. This makes a smoother transition, and this gets you organized to a high level prior to death, because we spend a lot of time making sure we know what you own and where it is. It's certainly going to be a more expensive project than just doing a will, because it takes a lot longer. It's about a 6-month project, and there's a lot of time spent with the lawyer putting this stuff together. Okay, but nonetheless, for those people who want to be private and want to avoid probate, it's a great thing. Also, what this can do is reduce taxes in a couple of ways. Right now, the new administration is talking about modifying the estate tax exemptions. And as a result, we are paying attention to where that's going. Federal exemption right now is $11.7 million. We're talking about reducing that to $5 million. Now, even at $5 million, a lot of people, particularly in upstate New York, aren't affected by that. However, it no longer is hard to get to $5 million for a married couple. House IRAs, I see a lot of multi-million-dollar IRAs now, because we're getting, first of all, the market's been very good. Second of all, we don't have pensions anymore for most people, and people are starting much earlier with their IRAs. This is a whole generation that started 25 years ago with the IRAs. I know I did 27 years ago, which means that the compounding effect of these IRAs is enormous. And therefore, we're having a lot of people my age, mid-50s, being able to put aside a lot of money by the time they retire. It's very, very large. So there's a lot of things we're paying attention to right now. We don't have the exact numbers on where the taxes will end up, but it's something we're paying attention to for sure. So the revocable trust is great because it manages stuff while you're alive. And if you become incapacitated, you will appoint a successor trustee to take over very quickly if something happens. And then they will manage the stuff until you pass, at which point it'll be distributed. So I'm going to talk in a minute about how things are distributed under a trust and why they're different, what they do, because I'm going to do that with respect to my next trust. So as I said, there are two main trusts. And so Bonnie, for your question, this may become very relevant because this is what most of my clients see me about. So this is, and I'm going to draw it. Don't comment on the artistry, I apologize. But what I like to do is draw pictures in an effort to help explain this stuff and how it works. Sometimes it can be complex. I want to keep it simple and understandable. So I draw this little picture.
It's a safe.
It's a safe. Yes, it's a safe. So this safe is our irrevocable trust. Why do I draw it as a safe? Because with an irrevocable trust, most of the time people are trying to protect their assets from something. Generally speaking, it's from the nursing home. You may or may not know that right now, probably starting in January, the nursing home is going to be $12,000 a month. So for even the reasonably wealthy, $12,000 a month is a lot of money and not the kind of money that people want to spend, because most people feel as though spending that kind of money on a nursing home is not money well spent. Unfortunately, don't get me wrong, I love nursing homes because they take care of our loved ones. They do, by and large, a good job under difficult circumstances. Nursing homes don't have a large margin, even though that looks like a lot of money. Ultimately, most nursing homes are working on a shoestring, even though they charge that much. But what we try to do is get our clients to the point where they're spending as little as possible in a nursing home. And that means protecting the assets and getting you qualified for Medicaid. Medicaid is the medical assistance program funded by the federal government, administered by the states, and truly administered by each county, overseen by each county. So the way this works is we take this trust and we put assets into it. Generally speaking, a home. Maybe you've got a second home in Florida or a camp. Not uncommon for people to have a camp in upstate New York, of course. Life insurance. Sometimes we'll put money or investments in here, with the eye towards protecting these assets from the nursing home. If these assets are in here 5 years, then they are 100% protected from the nursing home. Okay, so 5 years in, before you apply to nursing home or go into the nursing home, this is protected. Now, there is a pretty big downside to this. The biggest downside to this trust is whatever we put in here, you can't take out and give back to yourself. There is no taking money out and putting it back in your pocket. So we pick assets that we all agree are okay being over here and we can keep our hands off. The good news is, if we've got your house in here, you can still live in your house. You can even sell your house. The money can go into the trust and the trust can then buy a new house for you. Okay? We can also use this money to help pay for this house, or improvements on this house, or a new roof, or a new furnace, or things of that nature. So as inside the trust, we can use funds and other assets inside the trust. We just can't take it out and send you on vacation with it or buy you a new car with it. Okay, now we do put a lot of stuff in the trust, but there are things we don't put in the trust. For instance, IRAs, 401ks, and the like cannot go in a trust. So they must stay outside the trust. Now, the good news is that Medicaid treats those as income. So that if you have $1 million in your IRAs, Medicaid can't force you to spend those. They can only force you to take a distribution monthly, add it to your fixed income, and calculate a contribution to the nursing home every month that by and large falls well below the $12,000 a month. Okay, so outside the trust are your what we call qualified accounts, IRAs, 401ks, etc. Your fixed income, so your Social Security, any pensions you might have between you and your spouse. And then we have our favorite category, which is our mad money. And the mad money for married couples, we retain approximately $100,000 plus or minus outside the trust, depending on the situation, depending on your age, depending on what you might need to buy. If you've got a car purchase coming up, we might retain more. If you have very high income, we might retain less. It depends on the situation. It's all fact sensitive, of course. All right. Now, this trust allows you to be the trustee. So you can be the trustee, which means you control everything inside there. You don't turn over control to your children. You don't turn over control to your friend. You don't do that. You retain the control. There are some lawyers who tell you you can't be the trustee. Well, I've personally drafted nearly 5,000 trusts where my clients are the trustees, and I've never, and probably filed over 1,000 Medicaid applications. It's never been a problem, not in any county in New York State that I've dealt with. So that would be probably close to 10 counties. So I can tell you with a high degree of certainty, you can be the trustee. I don't care what anybody else tells you. If someone tells you you can't, have them call me. Now, I do have some good news. Well, I told you you couldn't withdraw directly from this trust. You can distribute funds to the beneficiaries, who are most often your children. With any luck, you like your children, then they like you back. Because if you need money out of this trust and you give it to a child, will that child give it back to you? I hope so. Of course, if you don't think they will, then that's not the child to give the money to. That was, but we do often utilize children as a way to get money out of the trust. It is absolutely legal. There's nothing wrong with that. They don't, the key to this is they don't have to give it back to you. But of course, since they love you, they will, I assume. Most of the time, I would tell you, most of the time, the way we set up a good plan is the money outside the trust in this category here, which is the money that you're going to use to live on, to retire with, all that stuff. We usually create a plan over here that's sufficient, so we never have to do this. And it's, again, fact sensitive. You know, sometimes this mad money bucket's 200,000 because you're 65 years old and you've got 20 years before we're concerned about nursing home potentially. So we're very careful about making sure you have plenty of money. And while this money is available to the nursing home if you go in, this is the money we want you to spend to enjoy your life too. So this is not a plan that we create so that we limit your life and that we put you in a box so you can't have any fun. We have to manage the money in with the money out to make sure you get both everything you need to live on and have fun with and still protect what you want to protect. Okay. I'm not sure, Bonnie, if I've answered your question completely, but the fact is, these are things that you at your age would be starting to look at. Because you're still young, on the good side of 60, it sounded like, not quite 60 or close to 60, you probably should have a basic plan in place of some kind. And if you have large amount of assets, consider doing a trust of some kind, again, depending on the situation. For sure, you should have a power of attorney, healthcare proxy, and will. That's not even a question, particularly with all those children. I assume there's also grandchildren, which means if one of your children predeceases you, you want to provide the protection that I mentioned earlier for your grandchildren. It's not always for your children. You could lose a child, unfortunately. So let me take this one step further, because I think you're going to see that this is not only a wonderful plan for you, but it also becomes important for your children after your passing. Because what happens here is, let's say this person has 3 children. The trust comes down and then becomes the will, and it distributes to the children. But as you can see here, I'm drawing 3 little boxes. And the reason for the boxes is because when we deliver it to your children, we want it to go into a trust for them. This trust now protects these assets from their creditors, from their nursing home, from any of that stuff, while at the same time allowing them to withdraw funds anytime they want. How about that? There is no restriction like there is up here. They can take money out anytime they want. We call it protecting from the 5 Ds. The 5 Ds are divorce, disability, disease, death, and debt. So what I mean by that is if your child's in the middle of a divorce, we want the money in this box so that that is not subject to their divorce. If they're disabled, if they're receiving benefits from the government, if this money would disqualify them from receiving those benefits, we want this money placed in what's called a special needs trust, which means now the government can't touch it and can't force them to spend. Really, really important. If they're sick, if they're running up medical bills of their own, if they're in a nursing home. I've had clients who in their 90s died, had their own children in their 70s in nursing homes. We want this money to have a wall around it so that the bad guys can't get to it, whoever the bad guys might be. If the child dies before you or shortly after you, most people don't understand. If you have a will and leave assets to your child, and the child dies 3 weeks after you, the child has inherited your money even though they don't have it yet, which means that that money will pass through their estate, probably in all likelihood going to their spouse, your in-law, your son-in-law, your daughter-in-law, as opposed to your grandchildren. With this, comes down to the trust captures it. The trust says, okay, if this person dies, then I'm going to send it down here, thereby protecting against the possibility that your child passes before or even after you. And of course, the last one is debt. If your children have debt, if they file bankruptcy, if they're on the brink of bankruptcy, we may want to protect this. We certainly want to protect this money from creditors and things of that nature. Okay. Now, when it does come down to your grandchildren, of course, once again, we put it in trust till they're 25 or 30 or 35, because we want to protect them down here. So we protect you while you're alive, your children from the 5 Ds, and then your grandchildren till they get to a more mature age. So this is a 3-tiered asset protection plan, geared towards protecting you, but also making sure that you've got a good orderly estate plan in place. This too avoids probate, which means that at the time of your passing, the passing of the funds onto your family occurs faster, less expensive, and is relatively orderly because ideally we've kept in touch and we've maintained a good list of your assets. What we do when we create a plan is we have a spreadsheet of your assets that we keep track of every couple of years as we see you over time. And we're able to make sure that we know what you own at the time of your death, making the transition from here to here easier. Okay, I hope that makes sense. And I hope I'm hitting on some important things for you to think about tonight. Okay, so this is our asset protection plan. Very important, one of our biggest plans. This is what we do most of. Now, I want to take a few minutes. I'm trying to keep this to 45 minutes, but I do think it's important to explain the basics of Medicaid. So just to reiterate, I've touched on the basic planning. I've touched on trust planning. I don't get into tax planning too much on my basic explanation because that's more of a high level thing. If you do have more than $10 million, well, please give me a call because we need to talk about it. And now I want to touch on Medicaid because Medicaid is certainly one of the most misunderstood legalities, one of the most misunderstood processes. And I'm going to do my best to explain it to you in a fashion that keeps it simple. It's not simple, so I'm going to do my best. So I think if you know anything about Medicaid, you've heard of this thing called the 5-year look back. The 5-year look back is simply a period of time. So if you go into, if this is here's our 5-year timetable. If you go into a nursing home here, so let's call that November 1st, 2021, and you apply for Medicaid. Medicaid says, that's great. Please provide us with 5 years of all your financial records. I mean all your financial records. I don't mean some or a little bit or part of it. It is all your financial records for 5 years, which includes monthly statements for all your bank accounts, your investment accounts, your IRAs, your life insurance, your cash, everything. They also want to know and want to see copies of every check you wrote for that period of time of $1,000 or more. Okay, so we've had Medicaid applications that are this thick. We've had them that are this thick, literally 4 feet thick. We've had to bring them to the county to file them. If you have someone with 20 different accounts, maybe you need 5 years of records. You know, some of those records are 15 pages a month. That's the size of the thing you have to turn in. So the 5 years only is the records you have to turn in. If in this 5-year period, somewhere on this timeline, they see that you transferred your house to your kids, which, by the way, I didn't mention this before and I should. Here's when you should transfer your house to your kids. I get this question a lot. You guys should write this down. Okay, I'm going to put it down in big letters for you. Okay, write that down. When that date comes, that's when I want you to transfer your house to your children. I know that's silly, right? You never transfer your house to your kids. There are a couple of limited circumstances where you might do it, but by and large, you don't. I've written an article in the Rome paper, and I can certainly, if you ever want, go on the website. I think it's on there too. The 9 reasons you don't give your house to your children. By the time you're done reading that, you'll understand what I'm talking about. So let's say you give your house to your kids 2.5 years before you go into the nursing home, and your house was worth $200,000. Medicaid sees that. They say, okay, we see that you transferred your home to your children. Very good. You want us to pay for your long-term care. You want us to pay the $12,000 a month. Well, here's the problem. You gave your house to your children 2.5 years ago. So we're going to assess this at $200,000. We're going to divide that $200,000 by $10,600. And what we're going to do is we're going to assess a penalty to you of 19 months, which means you are not eligible for Medicaid for 19 months. So from here to 19 months later, you have to pay your own way, which, by the way, you've already given away all your money and you have no money and you got to pay your own 19 months. Okay. Well, number one reason why you don't give your house to your children. Right? If you gave it to your children, you can't get it back. Guess what? Now we need that house back. I need to give this house back to you for various reasons, and particularly if you're married, I can get it back to the spouse. We've now exempted that house, protected the house, and eliminated the 19-month period. Very, very important that you concern yourself with that 5-year period. So Bonnie, one of the things you should be thinking about is if you were to do an estate plan or transfer assets to a trust or something, you want to do it out here, right? More than 5 years before you need the nursing home. Well, of course, since nobody knows when they need the nursing home, what we're doing is trying to get people to plan 5 to 10 years ahead of the worst case scenario so that they're well outside the 5 years. And we have little concern about worrying about this 5-year look back. All right. So what we run into in this 5-year look back is sometimes we see houses, sometimes we see gifts to kids. You know, there might be 5,000 here. There might be a wedding that grandma wanted to pay for. There's 2,000 there. Someone back here got 30,000 because they were in real trouble and needed some money. So what Medicaid does is, in addition to the house, they add all these little gifts up and they pile them into this whole number that they divide by 10,600, and they come up with a collective penalty period. And so managing those gifts and those transfers becomes really important. It's also really important that if you can't get this money back, that you have some assets available to cover that 19 or 20 months, okay? Really, really important that you manage your gifts and you're very careful about who you give them to and when. as you get, and part of the reason we give it to the trust is, think about this. If you made all these gifts into this trust, instead of to these people, the money is still there. So if we need this money years later, we still have it and we can access it. If you've given it to them personally and they've spent it, you can't get it back. Trust me when I tell you, getting money from a child is very difficult. We've been doing this for years. It's very, very difficult. So doing it in the right way to a trust is much more, much safer for you. Okay, now that is how the 5-year look back works and how the penalty period works. I'm now going to tell you, I'm going to give you some inside scoop on how we protect assets. So in addition to doing a trust and getting past the 5 years, there is another option. Let's say I have a person that comes into me and they've got a $200,000 house and $200,000 in cash. After we've spent down and bought the funeral and gave them they're allowed to have $16,000 to keep. After we've done all that, we can pay for children's funerals and things of that nature. This is what we've got left. So what we do is we go back to the drawing board and create a trust. Take these assets, we put them in the trust. So the house, 200,000, and the cash, 200,000. Well, Rob, you just gave away all the money. Now we're going to have a problem when you file for Medicaid and they see the 5-year look back and they're going to see the money. Yes, we acknowledge that. Well, what happens is this trust agrees to pay mom back $200,000 of this money at $10,000 a month for 20 months. Okay, so as the trust is paying mom back $10,000 a month, the remaining funds, the house, which if you recall, you divide that by 10,600, and that equals 19 months of penalty. The 19 months of penalty starts running as we're paying back this monthly payment. So by the time we're done paying back $10,000 a month, 20 months from now, the penalty on the house is run and the house is now safe. I did that really quick. I acknowledge I did that quick, and I acknowledge this is very confusing stuff. The bottom line that you must take away from this is that if you have someone, a loved one, going into the nursing home and have assets, it's never too late until they're out of money. It's never too late to protect some of this money. There are all kinds of tricks we can do to protect money. Sometimes I have people coming to me with $40,000. How do we protect it? And we can protect nearly all of it. More often than not, it's someone closer to this scenario where we've got about $300,000 to $400,000, which is comprised of a house and maybe some assets. Many times this generation doesn't have a lot of IRA money because IRAs started after they started working. So we're dealing with liquid assets of some kind in a house. Sometimes, quite frequently as well, we have a second home. And that's when we really have a problem because the family really wants to protect this camp in the Adirondacks. And they're really concerned about that. And so that too is, we utilize this trick, this process. Sometimes we have to sell some of the real estate to help pay the note. It's all part of the plan. Or I've had kids loan money to the trust to pay the note. Any number of things to make sure we get that camp or that house protected or whatever it is they want to protect. So there's a lot of ways to do it. There's also exemptions for disabled children. There's exemptions for children who live in the house with mom and dad. There's different things we can do to minimize the exposure to the nursing home, all very legal. But it does take work and it does take effort. And what does it also take? What was one of the first things I talked about? All of this takes a good power of attorney, because you cannot do all this stuff unless you have a very complete power of attorney that gives you the authority to do this. See, I cycled all the way back to the beginning to show you. So that's important. So I realize this is confusing stuff. I'm certainly happy to spend more time with you on a one-on-one basis to be more detailed and explain based on your circumstances as opposed to generic circumstances. So that is my soup to nuts basic outline of estate planning and asset protection. There is a lot more to it. My goal today, and I think I just hit the 45 minutes on the nose. My goal today is to try to give you the basics to both get you thinking and to generate questions that you might want to ask me on a personal basis. You're free to email me questions. I'll give you my email up here. So it's RKH, my initials, at HiltonLawNY.com. Free to send me questions. Understand also that we have a 1 hour, no charge initial meeting that anyone can utilize to discuss their personal situation. We do, as part of that process, send out a questionnaire ahead of time that you bring back with you, that we review at that time to go over your assets, your family. We dig into your situation, and then we talk about your goals. What is it you're trying to accomplish? How do I get from today to where you want to be? And then I give you options. So, oh, yeah, I'll put my phone number up here. So the phone number, 315. Oops, I almost put my cell phone number up there. 624-9600. Okay, so that's the office number. So please feel free to call if you're interested in meeting. Again, there's no charge. Part of the reason we do this, of course, is to generate new clients, but also information. And so my goal is to try to provide information to you. I also take these, and as I said at the beginning, we've recorded this on Zoom, and I will have it saved and then post it on our website so that if anyone wants to go back and look at it, you can do that. If I haven't hit on anything that you're curious about, please ask. If you've got something you want to know right now, ask it or email it, and I'll do my best to get back to you. If you give me a 5-page email with 50 bullet points, probably what I'll do is suggest that you just come and see me. That's just the best way. I'm happy to answer the questions, don't get me wrong. It's just for me to sit down and answer questions. I'm not a great typist. It's not really effective use of my time, but I am happy to talk to you about it, even by phone or by Zoom. I do a lot of meetings by Zoom. So, you know, if you wanted a series of questions answered, we'll set up a Zoom call and I'll go through them for you. Okay, happy to do it. Information is really important because that helps you not only decide what you need, but also when you speak to other people. I'm sure you get a lot of crazy information out there and you hear different things. You can do this, you can do that, this you can't do. You want to really know the facts. And so gather up those kinds of, that kind of information, those questions, and bring them in. We're happy to talk about it.
Bonnie said, thank you. You've given her much information and things to think about.
Oh, good. Okay. I hope so. That's my goal today. So I'm planning on doing these, generally speaking, the first Wednesday of the month for the winter. I didn't do them in the summer. I try to pick different topics so people can tune in and see something different they haven't seen last time. It could be important. I don't know. Pay attention to our postings, and if you want to come back, please do. And again, I look forward to seeing either of you or answering any questions. Thanks for coming, and let me know if we can help.
Thanks, Rob.
Thanks. How was it?
It was fabulous. We had a consistent 4 people and we were up to 7. But we had a consistent at least.
Oh, really?
Time.
Oh, I didn't know we had more than the 2.